Hello, this is Pamela, the Divorce Mystic. I'm an over 25-year intuitive attorney, mediator, and coach who's integrated a spiritual practice into my business. And for today's time together, we're going to move into part 2 of the In the Best Interest, Child Custody from the Eyes of the Bench series. As a reminder, in part 1, we talked about what the best interest of the child standard is, what does it mean and how is it used. We also looked at a couple of the factors that the court looks at when making a custody determination. We looked at the status quo. We also looked at propensity of one party or the other to foster a good relationship with the children post-divorce. We also looked at guardian ad litems and child custody evaluators, which will probably come up again. I want to pick up where we left off on the parent's propensity to foster a good relationship, because there's so much more that goes into that one little factor. One of the issues that's looked at is the concept of parental alienation. And that's kind of a double-edged sword, because on one side, you might have a case where the family was doing just fine, where one parent was, say, the primary caregiver, and the other one picked up the slack in other areas. And now they're divorcing. So the parent who did the primary caregiving is now being faced with the parent who did not do a lot of the caregiving, all of a sudden showing up where he never showed up or she never showed up before. They might show up at school, never did that before. Show up at practice, never did that before. Take them out to dinner or to games or to a movie, never did that before. Take them shopping, never did that before. So it's clear that in most cases, that other parent has talked to an attorney and the attorney has said, hey, if you want me to argue for custody, you got to give me something to work with. So if you don't have the bond with your children in that way, you got to create it before we go to trial or you're going to lose. That's the double-edged sword. Now we've got the parent who was the primary caregiver of the children during the marriage, sees this action from the other party and gets scared. What's the natural propensity to do is to protect herself or himself and their role as the primary parent. So they, in fear, and I'm going to say a lot of times innocently. I mean, there are people who get resentful and they're angry and it's just part of their personality. And no matter what, they're going to be this way. But there are a lot of cases where they're not that way. They just get scared and they don't know what else to do. And they want to, their primal instinct of protecting themselves and their children comes out. And they start doing things that are inappropriate. They start keeping the children from the other side or the other party. They start talking to the children badly and sharing things that they shouldn't share and trying to get the children to take a side. They know instinctively, people know instinctively what's right and wrong. But when you're in a situation like that, what's right and wrong goes out the door because you're so emotional and you're only dealing with moment by moment by moment during those situations. And like I said in part 1, there's not enough from the industry that is reminding parents that they truly are the best ones to make decisions regarding their children and leaving their children's fate and future, which is also your fate and future, into the hands of a court. And in most cases, right, one person, a judge who doesn't know your family at all, is the last resort. So moving on with that though, that multi-layer of that one factor moves on to, has there been any physical or sexual or any violence, any abuse of any kind? Because if there has been, then that analysis of is one party going to be, appropriate in terms of fostering a relationship with the other child goes out the window, right? Because the child's safety then becomes a priority. And then we're looking at a situation where there might be not just supervised visits, depending on what the issue is, depending on the evidence of what's proven to have taken place, and whether or not it's in the child's best interest to have limited time, whether it's in the children's safety or interest to have alone time, or does that any visitation, must it be supervised? And if so, how? There's certain facilities that do just that. They have supervised visits, and that's all they do as their business. So if there's a situation where there's abuse, then there's not going to be a discussion an analysis. And in most cases, the party who was the nonviolent one will usually end up with the primary custody. Now, I'm not saying that's 100% across the board. I'm just saying in most cases, that would be the result. But another issue that the court looks at, or another factor, is what is the mental health and physical health of the parties? Age comes into play too, but usually that's less important than the physical capacity to take care of the children. And is that matched with the children's health and their needs? So when you look at the balance there, what is the parents' health and mental state? And do they have the capacity, when you look at the children's ages and their needs, do both parents have the capacity to meet those needs? So as an example, a parent has a bipolar condition and they're on medication and they're doing just fine. They've been on this medication for 20 years and they're doing just fine. In that situation, of course, the other parent can use it. He or she's bipolar, and make a deal out of it, right? But at the end, when it's determined that the person's been working full time, taking care of the children, there's never been an issue, the other party has never said, I can't leave him alone or her alone with the children because of this condition, it's most likely that that's not going to get much airtime. It may get airtime, but it's not going to result in anything against that party. Versus a case where, let's use the same example, the person's bipolar and they make the decision to get off their medicine whenever they feel like it. They just randomly get off their medicine and they act crazy. So when the parties were married, it's okay because the other party took over. So if there was an issue, the other party immediately took 100% care of the kids and kept them away from from the other parent until he or she was back on the medicine and everything went back to neutralized. In that situation, that might have that one factor, or that fact in that factor, that layered factor, might have more meat or substance to the judge in terms of, I need to be a little bit careful here. May want some more evidence, may want an expert opinion. Who knows, in terms of, like I say, each case is different, but those are some of the things they look at. Let's say that one is ill. One has one of the children are ill and they have special needs that requires specific knowledge and attention and training to be able to deal with it. Is one of the other parties more capable of dealing with this child's special needs, as an example? And anytime there's a situation where both parties are equally capable, it's very rare where you get a situation that just because this person, it never happens, this person cooks, this person doesn't, therefore, of course, somebody who cooks is a better parent, they should get custody. No. It is a factor to consider, but in most cases, a court can see in most cases that both parents are fully capable of taking care of children. There are those isolated events, like I said, if there's physical abuse, mental abuse, sexual abuse, anything like that, no, it doesn't matter. At that point, it doesn't matter because we're only looking at what's in the best interest of what do I need to do, strip this way down to the most basic level. What do I need to do to protect the interest of this child or these children? So in terms of the mental and physical health of the parents and the children, I know that seems quite obvious, but like I said, with the bipolar, it could go both ways. There is a tendency now of everybody to use the word narcissist, right? How do you divorce a narcissist is really popular. But the judges are smart, and they know that every single person in the courtroom, as well as the professionals, as well as the expert witnesses, as well as everybody else in the world, all has narcissistic tendencies. It's whether or not they're present or they're being used. So a judge is smart, and if you're going to use those words, use them wisely. Instead of saying, unless there's a diagnosis, instead of saying he's bipolar or she's bipolar, or he's narcissistic or she's narcissistic, instead of doing that, make sure your lawyer specifically sets forth what the behavior is. Don't diagnose it unless it is a diagnosis. He or she's been diagnosed with this, and this is and he or she is on medicine, etc. If it's not diagnosed, then it's just putting forth the behavior. It's easier to prove behavior than to be caught saying something that's not true. So when you're looking at mental health, physical health, you're looking at both the parents as well as looking at the children, and making sure, again, on balance, which parent or both, are they capable or not of taking care of these children's particular needs. Now, when we get into specific needs, such as special needs education and things like that, and decision making, that all falls under the legal custody. So in the event that in such a situation that the court feels that each party can manage or handle a child's special need, but in terms of the decision making, if they can't agree on the day it is, or what the weather is, or what time of day it is, they're not going to be able to make good decisions, joint decisions. So in that case, it may affect that legal custody, so that the judge may consider maybe one of these parties or the other should be the one that makes all those legal decisions, and then the regular day-to-day parenting, depending on who the children are with at the time, can make those decisions based on day-to-day things. But the overall overriding umbrella decisions that would be under the legal custody umbrella, maybe that should be done by one. So again, as you're going and listening to the factors, they're multi-layered. There's many things that go in them. There's many ways of presenting the information to a court, but every single issue that is raised has to be shown by some piece of evidence that is, one, admissible, and two, proven. It's enough to prove whatever the allegation is. So be very careful before you file a pleading. Look at it. If the attorney drafts a pleading and you're heading towards litigation, just make sure you look at it. And do you feel good about this? Are these allegations accurate? Although they sound good, are they accurate? Could you be caught with, your pants down, as they say, and lose your credibility? Or are they substantiated, can be substantiated, and it's really important in order to meet that best interest of your child or your children, you've got to have this in here, and you have the wherewithal to prove to a court in a satisfactory way that it had a reason to be there, and it was indeed necessary, and it was indeed necessary to protect your children. So where we're going next into the further factors, this is why this is part of a series, because these little details and the nuances are extremely important. You can just say the health of the parties, but if you don't really understand how that plays out, the mental health, how that plays out, a lot of times, like I said, it's a double-edged sword when you have these factors, because on the one hand, people have legitimate concerns, and on the other hand, some people, the concerns are calculated, and in order for a judge or a court to make a solid decision on what is in the best interest of a child or children in such a case, they've got to weed through all of that. That's why, one, it's best if you keep yourself out and your children and your family out of the court system. But two, it's important to recognize and remember that your family remains a family even after the divorce is final. In a lot of cases, before the ink is dry, when families have allowed a court to be the decision maker, they've allowed attorneys to talk for them in terms of their main arguments as to why. They not only have lost their sense that their family really is a family and continues to remain a family, but before the ink is dry, they are already planning and strategizing for the next move. And that family stays, even though it's a family, that family stays in the court system for everything going forward. Every little dispute, the one who's not happy is already strategizing on what I can do to get this to be changed or modified. The one who thinks they won or feels like they won realize they really didn't win anything because nothing's changed. There's still a lot of animosity, and they're kind of looking at, if I really want this, if this is important enough to me, is it worth me putting money to file another pleading to get my way on something, or to force something or compel something? So that being said, part 3 will look at some more factors and some more details. But the most important thing as you're listening to all of this is to remember, always remember, if there's an opportunity for you to speak to your spouse, to, who cares, pull a chair and say, listen to this woman, right? Listen to her, and make a decision. If there's any way that you can prevent yourself from getting tangled up in the court system, as I say, becoming under the spell of the court system, that's going to be your better option. But if you have a case that is in litigation, you need to be in litigation, there's legitimate reasons and allegations that you've brought forward that must be there, and your cases, just make sure that you remember the word integrity. Always maintain your integrity. Don't let another professional, even if you're paying them, take you out of your own integrity. This is not legal advice. This is simply wisdom from many, many years and watching many families fall into the trap and they can't get out. So what's best for you will be learned and known once, or if you have, but indeed you must have legal information from your own jurisdiction. What are the factors that are important in that jurisdiction? What are the facts of your case? What do you need to know? What do you need to do? And what is going to be in your best interest is all going to be defined by seeking a professional in your jurisdiction. And if you're not certain how to hire an attorney, what are you looking for? There's a video that's out there by me that's dealing specifically with that. So know you've got this. If you're in fear, know that at least all is well with your soul. But there are professionals that can help you. Seek the right help that you need. If, of course, there's abuse or anything on the violent side where your children or you are at risk, seek the help right away. Forget what I said. Go to the police. Do whatever you need to do to protect you and your kids. But if that's not the case, just remember that philosophy. Your family, still a family. After the divorce, you're still a family. You just look different. And if you could keep that in mind on every decision that you make, and hopefully, have good conversations, meaningful conversations with your spouse to remember the same thing, then you will be, at least halfway there to being able to develop a good co-parenting relationship for the two of you. You've got this. Until we meet again in part 3, namaste.